are you doing? Reading my stuff. Get off my phone, Taylor.
That's 2 minutes to go. If everybody hasn't signed in, please sign in over here in the corner, please.
Taylor, she's trying to. Jump, jump. Jump, honey. You're ready.
All those of you online, if you don't, please mute your microphones, please.
Get up here. Come on. Hike up. Jump.
One minute to go. Those of you online, except for our Commissioner Rigsby, would you please put yourself on mute? Yvonne, you guys ready?
Hey y'all, can you hear me?
Yes, sir, we can hear you.
Okay, good. Sorry I'm not there in person.
Well, you know what that means. You know what that means, right?
I got the note. I don't know if I agree with the terms of that note though.
Ask Ron what happened when he missed a meeting last year.
You got elected to a new role, huh?
1 minute to go. Those of you online, except for our Commissioner Rigsby, would you please put yourself on mute? All right, so it is 2 o'clock on this beautiful February 7th. Thank you all for braving the weather and being here in person. I appreciate y'all showing out for this. Can I get a roll
Hey
call,
y'all,
please?
can you hear me?
Yes, sir. Yes, sir, we can hear you.
Okay, good. Sorry I'm not there in person.
Well, you know what that means. You know what that means, right?
I got the note. I don't know if I agree with the terms of that note.
We're delayed. We're somehow delayed recording. Ask Ron what happened when he missed a meeting last year.
You got elected to a new role, huh?
1 minute to go. Those of you online, except for our Commissioner Rigsby, would you please put yourself on mute? All right. So that we have kind of an echo in the house. So it is 2 o'clock on this beautiful February 7th. Thank you all for braving the weather and being here in person. I appreciate y'all showing out for this.
Jacob, can you hear us okay?
Yes, I can hear you now.
Okay, is it going weird and echoing?
Not at this time.
Okay, could you do me a favor? Could you bring me up on Zoom and just type in Village of Ruidoso and make sure you can hear us on that one?
Yes, give me 1 second.
Thank you.
Oh, it's you. We're just letting the snow build up some more, so it's all right. All right, Jacob. Are you hearing us on Zoom as well? And YouTube and everything else?
Yeah, I think we're all good.
Very good. Now, we can call this meeting to order. The Planning and Zoning Commission meeting of Tuesday, February 7th is called to order. Can I get a roll call, please?
Commissioner Briley?
Here.
Commissioner Baugh? Here. Commissioner Byers?
Here.
Commissioner McElina? Here. Commissioner Richardson?
Here.
Commissioner Rigsby?
Here.
Absent is Commissioner Williams. Also present is Stephanie and Myrna for the Community Development Department, Zach Cook, and Officer Minner. You do have a quorum.
Thank you very much. Declaration of conflict of interest. Does anybody have any conflict of interest that they wish to disclose at this time? I do have one. We do have a case on Meacham, and as I've told the commission before, I have an obligation to my employer, who's the Highway Department, for access, and I will be commenting on that. If that's a conflict, you can tell me to abstain on that item. If not, hearing none? Very good. Certificate of compliance, please.
I do certify that the meeting and properties were posted in accordance with Resolution 2301 and Section 5440 of the Municipal Code.
Thanks, Stephanie. Can I have approval of the agenda, please?
I move that we approve the agenda for February 7th, 2023. Second.
Have a motion and a second. All those in favor say aye.
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 Approval of minutes, regular meeting, January 3rd, 2023. Did everybody get a chance to read it? Do we have any ideas, suggestions, mistakes? Any motions?
Mr. Chair, make a recommendation of approval of the minutes. Second.
Have a motion and a second. Can I get a roll call vote, please?
Commissioner Baugh? Aye. Commissioner Briley?
Yes.
Commissioner Byers?
Aye.
Commissioner McElina?
Aye.
Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Motion carries.
Thank you. This is part of our agenda. It's public input. This is where we have that anybody wishes to speak on something that is not on the agenda. I know all of you didn't brave the weather just to come out and visit with us. So is there anybody that wishes to talk about something that is not on the agenda today? Seeing nothing in here. What about online? Anybody? Very good. All right. Item 6, petition for rezone, case RZ 2023-1. Mr. Remington, Stephanie, you want to give us an update, please?
Today we have a request petitioning to rezone a section of the property located at 114 Drive, Tract B1 of the Green Meadows addition. He is requesting to move from the R1 single-family residential district to the R2 two-family residential district designation. And Mr. Remington is present for questions.
Glenn, why don't you come on up? Tell us what you want to do.
We don't have any plans just yet.
Understood. Yeah. Glenn, can I get you to swear in, please?
What do you want me to say?
Swear to tell the truth, nothing but the truth.
I swear to tell the truth and nothing but the truth.
State your name, please, for the record.
Glenn Remington.
Tell us what your plans are or ideas are.
Well, build some apartments, duplexes, whatever we can do. There's a certain density that goes with R2. We would probably maximize that density. I mean, we got the village building trailer park, so I think there's a need. So that's about all I got to say.
Of course, we'll have some questions as well. So, a couple questions. So, I see in this plat that you gave us that there is, the subdivision is not part of this. We're just rezoning the entire tract, not the two pieces. Is that correct?
There was a replat done in December. It did section off the full tract into two separate tracts. He is only requesting the lower portion towards the Apache Hills Drive to be rezoned. The top portion would remain as designated as the R1.
So R1 on the lot B2 and an R2 on the lot B2. I'm sorry. R2 on the one and one on the two. Got it. All right, so there was also discussion about the vacation of Green Meadows Drive. Has that been done? Did we vacate that? Did the village vacate that road?
It was determined that there was previous processes taken but not completed. So the vacation was never done through a complete standard. We do have a petition to vacate the Green Meadows Drive that would be heard next month, but that is not part of the hearing today.
Questions from the commission? All right, we will get into a public hearing. Thanks, Glenn. And again, I need to remind everybody, quasi-judicial means you have the right to cross-examine and use whatever each other is saying as if we're in a court of law. That's kind of my joke about the bailiff, but so sorry about that. So anyway, we're going to open the public hearing. So I assume there's a few people that wishes to speak for or against this. If you don't mind, raise your hands or just stand up because I'm going to swear you all in at the same time. Raise your hands, please. You swear to tell the truth, nothing but the truth? When you get up and state your case, would you mind stating your name for the record, please? Those of you online that may wish to speak for or against, I'll give you a chance after the people that are here. So, who wants to be first? Speak for or against? Yes, ma'am. Come on up. State your name again, please.
My name is Dana Lenzo. I am a resident at 202 Keys Drive. We bought the house over 20 years ago. A little bit of background that some of you have probably heard before. My mother married the Swearingens. Henceforth, the gentleman who developed the property was my grandfather-in-law. Shortly after we put the house in, We had him over for dinner and he sat in the dining room window and he looked outside and he said, "I'm so excited you have got this amazing jewel of a piece of property in the village of Ruidoso. You will forever have the forest and the animals in your backyard because this is a designated watershed." And that was what it was supposed to have been done by Swearingen and Appraisal when they developed the property along with Conrad Keys Sr. Unfortunately, somewhere along the line, papers got lost, papers got moved, and it was never, I have not been able to find it as per the originals that are on file with the county assessor's office regarding the drainage. However, first thing I'd like to point out, and how do you want me to do this and give it to you, or do you want it, Mr. Briley? I'm not sure what it is. It is some exhibits. Exhibit number 1 is a copy of the actual plat from the county assessor's office signed by Dan Swearingen and Corinne Swearingen in 1961 that has the Wingfield Street continuing between the Markham and Buckner properties that feeds back into Green Meadows Drive, which y'all were discussing about having the vacation of right-of-way that was ruled on by planning and zoning. It was never followed through. However, what I'm trying to point out with this is there is a name for the drive back there. It is considered Green Meadows Drive. So when I got my letter and said 114 Keys, I thought, there isn't a 114 Keys. There hasn't been a 114 Keys for 60 plus years. So I would like to point out that that accurate description needs to be addressed as such. It fronts Green Meadows Drive. It does not touch Keys Drive anywhere in any way, shape, or form, including by access. So that is the first inconsistency, and here is the original copies of the county assessor's information that I have for y'all. Number 2, when we bought our property and put in our paperwork for title search, we were also presented with the current restrictive covenants that came with the property that were originally amended in 1958, and then again in 1961, and then again in 1999, in which case there is quite a few things in this I would like to point out to you, and you may have to look at this later. For starters, on page number 1, number C, says no residential lot shall be re-subdivided into additional building plots. Number G says no multifamily dwelling unit shall be permitted on any lot in the tract. And in P, it says no building shall be erected on any lot until the construction plans and specification and plot plan have been approved by this Architectural Control Committee as to workmanship, materials, harmony of external design with existing structures, and as to location with respect to topography and finished grade elevations. The Architectural Control Committee is composed of Burl R. Peterson and Beverly Sue Peterson. After Mr. Peterson's death, I do believe that Larry Forsyth, who was one of the property owners, talked to Mrs. Peterson, and he is currently alive, and she is currently alive, and she put him down as the second person on the Architectural Control Committee. So we do have an active committee regarding that until 25 years at least from the date of that in May of 1999. I'm going to give you a little bit of history because I found out that because this has a new name and a new description, that you are not required by law to look back at the previous administration. The respect that I am affording you is the same respect I have afforded every other person that has sat behind this desk over the last 20 years regarding the Planning and Zoning Committee, is that you are considered the ruling body, yes. And I do not doubt that and unequivocally will share that with everyone. However, I would like to say that with the respect that I afford you, I expect you to afford that to the same people that sat in the chairs in the decades before you. So I encourage you to do your due diligence. We have here a copy of the 2018 proposed plat from Mr. Peterson, wanting to put in, I believe at that time it was 17 houses. Then we have in January of 2021, there was a simultaneous submittal on prelim and final platting to which the engineer hired by the Village of Ruidoso, once confronted with the fact that it was a prelim and a final plat, backed off and recused himself from having anything to do with it because the work was not done to what he believed it should be done. There were too many errors with what was submitted to him at the time. So the village's own engineer backed out of that one. We also have here, this is the copy of my letter that I got.
Ma'am,
Yes, sir.
I'm gonna,
I'm gonna push you along. It's why I'm going through them real
it's been
fast.
5 minutes and I want to give
Yep.
everybody else a chance.
Well, you'll see this in a second. This is back in 2015. He tried to do it also. We have the copy of the planning from 2007 when Burl Peterson was denied turning it into 11 single-family lots. We have also here from August of 2008 when Burl Peterson was denied turning it into 8 lots. We have here a topographical map, which is very important in what you are looking at because where he is looking to put low-income housing, which means people who do not have enough resources to be able to afford to replace what might get lost. He's looking to build with substandard dirt brought in from the hospital area that was considered non-compactable by the state and so therefore hauled off. He's wanting to build your roads with it in this development where there is a stretch in here that goes across and has about a 40-foot difference from the top to the bottom elevation of where he is looking to put this. So unless he is planning on putting a parking lot and apartments on stilts, this end of the property, as referred to by, at that time, Chair of the Planning and Zoning, Ray Alborn, and a couple of the members of that committee back in, I believe it was 2006, they have said that this northern end of the property was considered undevelopable, that it was not supposed to be developed, and they told Peterson that he was not allowed to bring forth anything regarding development on this end with the exception of possibly 6 houses on the southern end of the road. So I want to enter this into your evidence, please.
Give that to Stephanie, please. Mr. Remington, I saw your hand up. Do you want to cross-examine? Thank you for your input. Who would like to be next, please? And again, I'll give everybody the respect and try and give you 5 minutes, as long as we don't re-enter all the same information over and over and over. Hi, please state your name.
Afternoon, gentlemen and ladies. My name is Christopher Sanchez.
And you swear already?
Yes, sir.
Okay.
I live at 112 Keys. I am the new owner there. I purchased this house back in May. So I now reside in what was old Kate Gateman's old home. My objections, since I'm fairly new to this part of the neighborhood, I actually grew up off 2nd Street and 3rd Street on A Street. I grew up there as a child, lived there. Now I moved to this part of the city. Part of my background is I'm a retired lieutenant colonel. I served 6 tours in and out through war zones. I came here to live in peace, and that's all I'm asking for. So one of my problems is that 114 Keys, if that's how they're classifying it, creates a road hazard because I will be right next to that road. It forms one heck of a dogleg. Also, the increased traffic will probably keep me alert a lot. At the same time, the people across the street also complained that there'll probably be a lot of light problems coming from traffic going back and forth across that road. Plat development, as Mr. Remington has stated, he doesn't have any development as of present. There's no plans, anything like that. So that's an objection. But as Dana said, everything that has ever been brought up has been questioned and denied so far. When looking at that property, it's a drainage location. It's heavy, it just kind of forms off and it drains off into 5th Street. And I have seen some of the videos of what 1 inch of rain will do, which also could affect our property up off of 2nd and 3rd Street if that road starts getting destroyed because of the amount of flow through the region. Other than that, that's about all I have on my objections for the property.
Thank you.
Yes, sir.
Who would like to be next?
My name is Ron Buckner. I live at 200 Keys Drive. We've lived there over 32 years, and, it's mostly full-time working class and retirees in the neighborhood. We watch over each other and take care of things going on there and whatever. We already have a water pressure problem in our neighborhood. We have 2 large motels and the majority of the neighborhood being full-time residents. And we also have high traffic coming through there because they come through there all the time going up to Grindstone and whatever, trying to find the lake and whatever. If this changed to an R2, we're going to have more pressure on our roads, on our water, sewer system, and everything like that. The next question is, if this is going to be for a workforce housing or whatever, since that's what it's going into, we'd like to know what kind of a graph you have set up for that, being as you are putting in trailer houses and putting those in over there for the lower income people to come into. How much money do they have to make a month to be able to afford to get into one of these things? It's just a whole lot of things going to it that we want to know what could be done and how are they going to be able to afford it. That's all I got.
Thank you. Who would like to be next? Anybody here? Yes. Come on up, state your name, please.
My name is William Griffin. I'm an attorney here in Ruidoso. My office is at 2825 Sutterth Drive. I live just outside the city limits, or village limits. And I'm here today to represent a number of different persons and an entity, Trace Hermanos LLC, the Rennick brothers, Joni Markham, Larry Forsyth, Mark McCaffrey, and potentially others who've contacted me in their interest in opposition to the rezoning. And I hope that I'm following the last of the folks that wanted to speak about their personal concerns. I represent these folks, but I can't necessarily offer testimony. Judges always remind lawyers that what we say is basically useless. It's not evidence. So let me at least allow some words to come across my lips that may be of assistance to you in understanding the role as we, the public, see it that the Planning Commission plays. And I've got to admit that it's still somewhat unclear to me by what authority the Village of Ruidoso was able to amend its zoning ordinance to permit modification to designated zones to increase a burden upon the land. And that's what it is. I mean, some people may say that it actually has a benefit. And I'm sure that it's a good argument to say that there is a benefit to having additional units. But I would argue that as far as the law is concerned, it's an additional burden upon the land. Zoning, of course, is granted the authority for zoning adjustments and zoning determinations is given to municipalities through Statute 321.1 and sequencing. But the rezoning is a little bit distinct. Rezoning is a little bit different, and it turns out that there is not a specific statute that grants power to municipalities to rezone. So you might say, well, it happens all the time, and I know that it does, but it's not the kind of thing that can be codified. So what we end up with is case law that discusses how rezoning is done. And I won't bore you with a lot of that case law, but I'll also mention that the Village of Ruidoso ordinance for rezoning 5465 doesn't mention where it gets its statutory power to do that. So I'm just telling you that because from my perspective, it's a little sketchy that we would do rezoning, and then we see that there's advice against spot zoning. So spot zoning is probably more like spot rezoning because we don't just spot zone. You guys have a master plan. I respect it. I think everybody respects it. But I wanted to point out that where the statute authorizes a municipality to do such things as rezoning, we have to follow that statute closely. If there is no statute, what do we rely on? Again, we have to rely on a certain amount of case law. And without clear state-granted authority to affect property rights, and that's what you're doing when you say we're going to rezone a particular area. You affect the property rights of the person who is asking you to change the zoning, but you also affect the property rights of the people who are in that same neighborhood and who may, and I hope to lead to this effectively, have a contract to preserve the way of life in that particular neighborhood. The village states that the purpose of rezoning itself, the Village of Ruidoso states in 54 65, and I quote, "These changes in zoning classifications are for the purpose of meeting the land use needs of the residents of the village in conformance with the village comprehensive plan." I had to read that a couple of times before I felt like I understood what it really was saying. But I think that that should be read that zoning changes should reflect the land use results of the residents who already live there. If there is no residents living there, then you can have a little more flexibility in rezoning. And it's not necessarily the aspirations of a new arrival in the neighborhood. With all due respect to Mr. Remington, I think one of my previous speakers mentioned that he came along just in the last few years. If the purpose here is ostensibly to raise the quality of life for 10 to 15 people on a 1.86 acre lot, then I think that we should at least, and I'm offering this again as a stimulus for thought, that we should also weigh that against the effect on the quality of life of the people whose neighborhood is forever changed by a change in zoning. So may I suggest that we ask what is the character of the neighborhood, then determine if the proposed change is in keeping with that character. And a well-spoken woman before me said that character of the neighborhood has been defined for a period of decades. In the simplest sense, almost the entire neighborhood is designated as R1 in Green Meadows Edition, which is what this is. It was called the Green Meadows Second Edition, now it's called Green Meadows Edition. And in the Green Meadows Edition, there are covenants, codes, and restrictions. And again, I think it's important to mention that those things are effective, but that's not necessarily your realm, and I respect that. But the village's own zoning ordinance states in R1 that the district is intended to be strictly residential in character, with a minimum of disturbance due to traffic and overcrowding. So we had a mention about traffic. I think that is a legitimate concern. In contrast, R2 states, and this is Ruidoso's own ordinance, shall be developed at a gross residential density of not more than 9 dwelling units per acre. I think that translates to approximately 15 dwellings on that new platted tract. And residential densities may be limited to protect the natural character of the village. Aha, so that comes up in R2. The village said that to itself. Less restrictive zoning to a certain extent that allows greater development is the antithesis of common sense. It is actually a down zoning. It is an additional zoning burden, as I mentioned earlier. 322.11 says if any other statute or regulation or other local ordinance, resolution, or regulation adopted under the authority of sections 321 through 321.14 is applicable to the same premises, then the provision shall govern which requires, and then they give us 4 choices. The provision shall govern which requires, and I choose C, the greater percentage of lot or land to be left unoccupied. So again, that means if it's R1, single development, single building, then you're not typically seeing that you're going to expand areas for parking, for curtilage, for yard, and so on and so forth for a second property.
Sir, I'm going to ask you to give you another minute or so be consistent with what I'm asking everybody else to do.
I'm grateful for that. So let me just point out that there's a couple of cases, important cases. The Cordonani versus City of Albuquerque, 1963, NMSC 146, stands for the preposition that we can appeal decisions. And now you're probably thinking, why do we care? Why do you guys care about all this? It's because 39.3.1.1 says that any person aggrieved by a decision of the zoning authority may appeal the decision pursuant to the provisions of that section. Why do I say that? Because this is a contract. Mr. Remington has a contract with us. I say us, I don't live there. My clients. Mr. Remington has a contract with us that was entered back in the 1960s that says we will build no non-single family dwellings. In fact, again, as I mentioned, there's a contract that's the CC&Rs. I always say it's a contract because that's what CC&R basically means. It's a contract. It means that somebody has to abide by it. And it's the kind of property right being affected is one that is why we have a quasi-governmental proceeding and why the decision has to be based upon neighborhood condition. And I think I'll just skip real quickly ahead to that one notation because I think it's important. This is Albuquerque Commons Partnership versus City Council, 2009, New Mexico Court of Appeals 065. the municipality must demonstrate that the existing zoning is inappropriate because, one, there was an error when the existing zone map pattern was created. Two, the changed neighborhood or community conditions justify the change, and we speak the antithesis of that. We believe that the changed community condition is what establishes that you can't go to multiple housing. And the third is that a different use category is more advantageous to the community. I submit that the community's impact is something that you have heard from some of these neighbors, and it's a little bit greater than merely taking property from a small density and taking it to a greater concentration of density. I think it's got a greater impact that also includes such things as property values, as we have
Thank you.
often mentioned.
And as I stated before, this is quasi judicial, and if there's more things that come up that you want to cross-examine, you may.
Thank you very much.
I bet. Who's next, please? State your name, please.
My name is Kevin Keys, and Conrad Keys Sr. was my grandfather, and I live at 111 Fifth Street. I'm not against these fellows trying to make a buck on their property, but I'm the one that's going to catch all the water that comes down that drainage. I've seen what it can do. I've been on that property. I'm 61 years old, and I've been on that property since my grandparents owned it, since I was born. So I've seen what's come down that ditch before. Now, concern I have is these roads over here, this Apache Hills Drive and this Timberwolf Lane, and they're gonna put apartments there. Are they gonna allow people to come in those apartments from that direction? And then they're gonna cross through that, whatever parking lot they have there, that's gonna go across over here to this other road, Meadows Road, and come out on Keys Drive? You know what kind of traffic that's gonna cause? I don't know what kind of fence they're gonna put. Are they gonna let them come in from that way? And as far as the benefit for the community, do you all know what kind of birthing area that is for the wildlife in this community? The horse people are gonna freak out, man. Those horses go back there and they have them colts back there. The elk have their babies back there. The main thing I'm worried about is the drainage, because everything's gonna come right into my garage. That's about all I got to say.
Thank you. Who would like to speak next? Anybody else? Anybody else in here? If not, I'll go online. Does anybody wish to speak for or against this rezoning? Raise your hand and they will let you in.
Speak for me.
Anybody? So I see somebody says is watching and would like to comment. Is that on this case or the next case?
This case.
Yes, state your name. I need to have you state that you swear to tell the truth and nothing but the truth, please.
I do swear to tell the whole truth and nothing but the truth.
Thank you. State your name for the record, please.
Tina Seal.
What is your address, please?
205 5th Street.
Yes, ma'am. What's your comment?
We are in opposition to the building that Mr. Remington proposes. My family has owned that property at 205 5th since 1957. And we just are not in agreement with anything multifamily or even single family, because like Mr. Keys noted, the drainage, it will also affect our property.
Is that all?
Yes, so we are very opposed to any construction of the nature.
Very good. Thanks for holding on that long in outer
Sure.
space.
Sure, thank you.
Anybody else online that wishes to speak for or against this project? Seeing none. Oh, go ahead. Yes. Come on up and state your name, please.
My name is Sam Rennick. I would just like to point out to the council that, and I believe one of the previous speakers mentioned this, back on January the 15th of 2021, a notice was sent to property owners from You, the Village, that Mr. Remington's request was to replat Tract B for 17 R1 single-family residences, January 15th, 2021. On October the 5th of that year, Mr. Browley, it appears that you have stamped a document confirming that the zoning will remain R1. So that's 10 months later. 11 months after this, Mr. Remington filed a Village of Ruidoso planning and zoning application in which he indicates that the R1 is what he wants to keep, the existing and the proposed zoning, R1. On the last workday of 2022, about 6 weeks after this, he filed a revised planning and zoning application in which he has changed the proposed zoning to R2. So about, less than 2 months later, he's changed his mind. He gives as a reason, due to overwhelming need for rental property, this piece of land is adjacent to R2 and therefore perfect for rezoning to multifamily. So apparently, this overwhelming need occurred in that 7 weeks between this one and this one. That seems curious to me. Moreover, his one reason for this, and when he spoke a minute ago, he had no reason particularly at all. He didn't seem to, I don't mean to be personal here, but Mr. Remington began with, we don't have any plans just yet. We want to build apartments, maximize density, trailer parks have the need. That was the sum total of what he said. Everybody else is well prepared for this. He is saying we have this overwhelming need that developed in the space of the last 7 weeks. He points out that there is one R2 parcel. It's, I believe, 2 blocks, and it does abut upon the gully he wishes to develop. The other side of this is the entire history of this property is as R1. Not only the restrictive covenants that I believe previous speaker mentioned, but the avowals by the city to the residents that it's going to remain R1. The entire history of this property is this, and he is saying suddenly we have this overwhelming need for low-income housing, and because one property, which is R2, abuts upon the property he proposes to develop, that is his reason for saying, therefore, you can make this R2 as well. So I would submit that his case is not as good as the case against him. Thank you.
Thank you. And if you don't mind giving those to Stephanie. And I guess I'm curious of what I stamped.
I believe I can find it.
Please. Was it minutes or something like that, probably?
I am unaware of anything that you have stamped.
Yeah, okay. Oh, good. Does that mean I can conflict myself out? Anybody else wish to speak for or against this? Mr. Remington, I'll give you a chance to state your case and kind of rebut whatever anybody has said, and subject yourself to cross-examine as well. Please.
So I guess the first thing, it's not low-income housing. It would be workforce housing. Someone did mention that. There's that. This is just a rezone. That's all I'm here for, is a rezone. Any plans I come up with will have to come back to this body for approval. So, you know, they're fighting a battle that we're not fighting yet. So I don't, you know, everybody knows this town needs more housing units. The village has said so itself. So, you know, I got a real good reputation in this town for quality construction. These would be also quality construction. As far as drainage, it's something we would have to address. But, I mean, these people, I don't blame them. If I was about to lose my private little park, I'd be upset too. Problem is, it's private property, my private property. And private property comes with rights. And I intend to exercise those rights no matter what these people think. So thank you very much.
Anybody else wish to speak for or against this or cross-examine? Anybody that has given testimony so far? Yes, ma'am. Please come up.
I have a very brief statement. May I just stay here?
They can't pick you up on the microphone there. State your name for the record, please.
Bonnie Elizabeth Coe, COE.
You swore already? Yes, go ahead.
I have been in this town longer than the sum total of the ages in this room. And this is and I've been to many of these meetings. And what I see, when somebody needs something done, they will throw in an emotional appeal. I need to have this surveyed off so I can build a little home for my aging mother. I have a couple of ladies over here that want to go to church and they don't drive and they need to walk across the street. I have heard this over and over again. There's a tinge of emotionalism when you use the word workforce housing, because if you look at something, you look at what goes on in this town. So many people come in with, oh, here's another one. I love this town, I want to develop this, and I've set off a part of it where I want to build my own personal residence. You never see them again. The developers have done that to us over and over again. And so once something is zoned, whether it's single-family dwelling, multiple family, whatever, there's nothing to stop them from going short-term rental. There's nothing, it's always about an emotional appeal. Then they get what they need, and I have seen it time and time again turned into something else. So that's all I want to say for today.
Thank you, Ms. Coe. All right, anybody else? Okay. Yes, sir, Mr. Griffin.
Thank you. And I promise to be brief. Zach believes me. Now, this is truly a brief comment, but it was something done by Larry Forsyth. He did a little bit of research, and he did a public information request related to police calls in the Woodland Ridge area. And I suppose some could say it could be qualified in different ways. But ultimately, I would say that these were primarily between the streets where the apartment complexes are located, and the calls were made and generated and responded to in that area. And it came to 45 calls in the past 3 years, mostly for loud, noisy, ruckus, fighting, those kinds of things, domestic calls. And interestingly, if we whittle it down, it was 33 calls in just the last 24 months. Now, I don't know what that truly means. It comparative to my neighborhood, we don't probably have a whole lot of calls in my neighborhood. But that is a statistic that Mr. Forsyth thought we should share because Mr. Remington chose to point to Woodland Ridge apartment complex as, see, this is what we would have. Thank you.
Thank you. Come on up, sir.
The last comment about something, what did I do?
Glenn, please speak in the microphone.
Well, I mean, these people, they're ascribing all kinds of things to me that haven't happened, and I want him to repeat what he just said, if he would.
Mr. Remington, it was my understanding that you spoke of and pointed to the Woodland Ridge Apartments.
I don't even know where they are. Where are those?
Oh, okay. Well, it's the apartment complex that's right next to the land that you seek rezoning for. Woodland Ridge.
On Timberwolf? There's multifamily all over that place.
Guys, I need order. I need speaking into the microphone, please. If you wish to cross-examine, come on up to the microphone.
Okay, so now I know what he's talking about. I certainly wouldn't build anything like that. So, once again, bullshit.
All right. Anybody else? Ms. Seal, I see your hand is still up. Do you have something you wish to say again?
I was curious as to how long Mr. Remington has owned this property.
Ms. Seal, I don't know, but I hear somebody in the audience saying about 8 years.
And how many times in
No,
this 8
sorry.
years have you tried to develop it?
Okay, so you do wish to cross-examine the applicant, so Glenn, come on down. She has questions for you. This is acceptable in a quasi-judicial system. So, Ms. Seal, state your first question and then your second question, please.
How long have you owned the property? And within that time period, how many times have you tried to develop it, and what methods of development have you attempted?
We bought the property at the end of 2015. We've tried to develop it once, and it wasn't successful. And in hindsight, I'm glad it worked out the way it did.
Mr. Chairman,
Sir.
you guys are sitting in your quasi-judicial capacity, and in a courtroom, there are certain rules about what evidence can get in. Those rules don't strictly apply here, but it doesn't really matter how long he's owned the property or what he's tried to do with it in the past for purposes of today's application.
He is the current applicant.
I would submit that everything that has come before is irrelevant.
Very good. Thank you. Okay, one last time. I'm going to close the public hearing. Commissioners, questions that you have from the applicant or the residents?
Chairman Briley, I have a couple corrections I'd like to state from testimonies that I've heard.
Okay,
Okay, just,
is that acceptable, Zach? Go ahead, Stephanie.
the first question that was posed was about the addresses and how it doesn't format. That address is dictated by GIS and follows formulas. as that entrance point comes off of the Keys Drive. That's where that came from. It's not dictated by a personal property owner. If developed or anything, a new address would be provided. The questions here from Mr. Rennick on one of the applications, it shows the proposed zoning change and the current zoning change was the same. That was an application that shows for the replat to be taken. Replats do not allow for the request to change zones, so that would be why there would be a second indication of application that would do that. For the state that there was only one parcel adjacent to the property within R2 district. There are 13 parcels within the immediate area, all following the R2 district. There's also multiple family structures located within these properties and not just the one developed at the bottom of Apache Hills. There's an apartment complex and multiple duplexes that follow along Lee and Timberwolf. So just so you know. On the written notification part, we did mail 23 letters. One was returned as undeliverable. We received 4 written opposition letters. Only one was within the notification area, and that gentleman actually made his comment here today, being Mr. Sanchez.
Very good. Anything else?
Yes, clarification for the need of the housing. The request is in conformance with the comprehensive plan and the housing needs study that has been performed and stated as a need for over 20 years by the Village of Ruidoso. The staff does find that this is in accordance with the zoning ordinance of 5465. The staff does find that granting the rezone would not adversely impact the health, safety, and welfare of the properties. And then the staff also finds that the property is contiguous to the R2 district, so it would not be a spot zone. And staff recommends that all site plan and concept approvals as set forth in section 5467 be required prior to any development to ensure any of the concerns of access and egress and also drainage be able to be mitigated at that time.
Anything else? So the commission has the, I guess, the pleasure of listening to the testimony and to make a determination of rezone. Again, this is not anything to do with a future site development, how many things are going to be on the property. That has to come later. This is strictly just a rezone hearing. And again, the commissioners need to remember that this is just a recommendation to the council. If you vote for it, then it will go to the council for another public hearing. And if it is denied, then he has the right to appeal our decision to the council as well. So with that discussion, any questions that any of you have? Is there any motion, any activity you want to propose?
Since we're looking at, since we're looking at actually two lawyers telling us what the law is and what the potential of it is, where are the pitfalls for changing the zoning? Is there legal standing for us not to? Is there legal standing for us to change it?
Mr. Chairman, Commissioners, I think Mr. Griffin raised some really good points that our statutes, everything that a municipality can do is because the legislature through the statutes gave them the power to do it. The legislature clearly gave municipalities the power to zone, but they're silent on rezoning. And so that leaves us with the courts, and the courts have clearly made rulings on rezoning cases. So, it's not in the statute. The courts have ruled on rezoning issues, so it's kind of hard to say that you don't have the authority to rezone. So then you go over to your statutes to our ordinances and look at the zoning ordinances, and it's codified here for the village rezoning. So I guess you could say that somewhere in time, the village included rezoning based on case law or whatever. I don't know what. All I know is that it's in our ordinances, and the Supreme Court and the Court of Appeals have ruled that municipalities have a right to rezone. So as far as your authority, I don't think there's any question that it would be nice if it were in the statutes. It's just not there. But the zoning is there, and the courts have ruled on rezoning cases. So does that answer your question as far as the municipalities?
Yeah, because I think what I'm hearing is everyone thinks that they already know what the plan is to build.
Mm-hmm.
And we do not know what the plan is yet. And certainly, when the plan is presented to the board, it's either a yay or nay for us in how they present the plan, the drainage, and everything else. So, right now, we're really just looking at the zoning.
Correct.
And, correct?
If you look at the purpose of the article, the zoning article in your ordinance, it says the purpose of this article, the zoning article, is to encourage the most appropriate use of land and to promote the health, safety, and general welfare of the community, whatever that means. According to you guys' evaluation of the evidence of what you heard today.
Okay, thank you.
Go ahead, Rick.
Mr. Chair, I have a question for our attorney as well. Within the ordinance of the subdivision itself, where does the zoning lie within that? How does the city override what was stated earlier?
I don't understand the question.
Mrs.
Are you talking about the covenants?
The covenants, correct.
Covenants are private contracts, and you guys, you could consider that the fact that there are covenants there, but that's neither here nor there for purposes of your decision on the application. If he starts to develop his property in a way that the opponents believe violate the covenants, then they have a private lawsuit that they can file against him. But it's not up to the village to determine people's rights in a contract.
Thank you.
So I'm going to follow up on one of Rick's questions, though, is the initial zoning of this subdivision back in the 50s or whatever, that was there even zoning then? And is that when it established the R1 zone? And that's I guess, my question. And I believe there wasn't zoning back in the 50s.
The earliest I can find is zoning was designated in the 70s somethings, when the ordinance was passed and approved and adopted.
Thank you. Any other questions?
Mr. Chairman,
Yes, sir.
I have a question. Stephanie or Zach, probably Stephanie could answer this question for me. How do you define a two-family detached dwelling, please?
Can you search two-family?
Is there a two-family or is it all just one?
Just this one. It should tell you two-family detached dwellings.
Hold on, Jacob. They're looking up the
Sorry, I'm trying not
definitions.
to quote it incorrectly. I have a very confident nature, but I want to make sure that I state it right.
I appreciate that.
Definition. It's 31, sorry. Be in the T. I think. Dwelling. Or definitions. Okay, so in the definition, two-family dwellings mean a building or portion thereof used for the occupancy by two families living independently of each other, also referred to as a duplex. I believe the addition of the detached dwellings allows for what are called patio homes, if you're familiar with that architectural style, where they're still built within the same jurisdiction and plot of land to be a two-family dwelling, however, they do not share a party wall.
Okay. Thank you. And the principal uses for R2 are single-family detached, two-family detached, and public parks.
That is correct.
Correct.
And all other forms of housing would require either additional use, and even then, there's a limit to R2 to not exceed 4 units. Is that correct?
Yes, so it's 4 units, not to exceed 9 dwelling units. So the dwelling units is deferred to differently in the definitions as units. Units would be the townhouse itself, being the 4, and then the 9 dwelling units being the occupational spaces within. So they could have up to 9, which is kind of awkward for a two-family dwelling as they have 2. That you would think that'd be 8, but I didn't write the code.
Thank you. Thanks for the clarification.
Any other questions? Mr. Rennick, did you find where I stamped something?
Yes, I did.
Thank you. Let me see, please. I didn't know I stamped anything regarding this. Maybe my signature on a plat or minutes or something.
Hand this to you. These are minutes from Planning Commission regular meeting, October the 5th, 2021. Got it. Take a look at where it's highlighted, if you will. I believe on the very last one more, right here. This is where it's highlighted. No, oops, sorry. Right here. We must leave it that way.
Okay, what he's referring to is a statement in some minutes that I also signed, so I didn't stamp anything, I just stated something. So I'd be glad to abstain if the commission thinks I need to. Then what's the commission's pleasure? Zach, there is a request that we ask the attorney some things in private regarding a executive session. Is that allowable for us to talk in the back with just the attorney? Okay. Yes, yeah. It's, yes. It's to make a motion to go into executive session for X reason to talk to the attorneys. Then when we, then. Yep. Okay, and then when we come out, we have to state that we only talked about the issue at hand.
Mr. Chairman,
Yes,
point
sir.
of clarification. Was there a motion for executive session or
Not
no?
yet. He's looking at the statute to refer to in the motion.
Okay, thank you. Sorry.
And Jacob, do we have your phone number so we could call you while we're in executive session?
Yeah, I'm happy to give it.
Okay. Stephanie thinks she has it.
I think it's on the website for the village, so quick Google search, you might find it.
Ladies and gentlemen, it appears that the commission wishes to talk to our attorney in private. We're researching the statute that allows us to go into an executive session. We will retire to another room if you all just plan to hang out and wait and see what the result of our discussion with the attorney is. Thank you. Bart?
Zach, can you repeat that for me, please?
You did.
I'd like to make a motion that we retire to a executive session under statute 1015-1 H3 of the New Mexico statute.
To talk about that case.
Okay, to talk about case RZ 2023-1.
Second.
Have a motion and a second. This requires a roll call vote, please.
Commissioner Baugh? Commissioner Briley?
Yes.
Commissioner Byers?
Aye.
Commissioner McElina? Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Motion carries.
So, ladies and gentlemen, we will step back into a back room here. It shouldn't take too long to get some questions answered, and we will be back shortly. If you all want to stay, take a health break, watch it snow, whatever you want to do. Jacob will call you here on the phone. We're back in order. Can I get a motion about the executive session, please?
Mr. Chairman, I'd like to make a motion that we come back into open section and make a statement that this commission heard nothing more than case report rezoning request of RZ 2023-1.
Second.
Motion and a second. Can I get a roll call vote, please?
Commissioner Baugh?
Aye.
Commissioner Byers?
Aye.
Commissioner Briley?
Yes.
Commissioner McElina?
Aye.
Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Motion carries.
So, Mr. Cook, do you mind giving us a brief on some of the items that were brought up at the executive session, please?
Mr. Chairman and commissioners and members of the public, throughout the hearing today, we had the applicant who pretty much most of his case, he stated that he doesn't know what he's going to do with the property and that any opposition to it is BS. And that is a summary of his case to change the zoning. And then you heard from the opposition, and their testimony was made up mostly of sentimental stories about the history of the neighborhood, as well as a lot of speculation about the possible traffic and light effects and noise effects and police calls, things of that nature. We had a good conversation that Mr. Griffin started about municipalities' authority to rezone. And I think that without putting words in Mr. Griffin's mouth, I think we agree that the municipality has a right to rezone because cases have, the higher courts have said that we do, even though the statutes don't. And then, so where does that leave us? Well, rezoning is underneath the zoning ordinances in your ordinances. And I read a little bit while we were in open session a minute ago, or a few minutes ago, about 5432, the purpose of the zoning ordinance. And 5432A1 through 8 gives us guidance about why zones should be zoned the way that they're zoned, including the prevention and congestion of streets and other public rights of ways, to secure safety from fire, panic, and other dangers, to ensure adequate light and air, to prevent the overcrowding of land, to facilitate adequate provisions for transportation, water, sewer, et cetera, to control and abate the unlawful use of structures, to protect the public health and general welfare, and to encourage the conservation of energy and the use of structures, buildings, and land of the village. The only evidence that you guys heard during the hearing that I could tell of came from your staff member, Stephanie Warren, who testified that the requested rezone is in conformance with the comprehensive plan, which would support the change. But if we're putting rezoning in the same area, legal area in our ordinances as the zoning, then I think that you guys should consider those things about why you zone certain properties a certain way. There was some, Mr. Griffin brought up some cases and said that those support the opposition, but when you read those cases, you'll see that it was actually the city that initiated the rezone in those cases, not the landowner. And the rezoning application was to make the use less restrictive. So they were going from a higher use down to a lower use. In this case is completely different than those in that it's the property owner asking you guys to rezone it to a higher use. So I don't think those cases are on point, and I can't find any cases that will give you guys the guidance that you need today. So I think that if the ordinances provide that a rezoning hearing can be postponed not more than 2 consecutive meetings. So if you guys aren't prepared because you haven't heard any evidence to sway you one way or the other, which leaves you in a position either way you go, you could potentially be making an arbitrary decision. if both parties would come back after, if we postpone this meeting and y'all come back and present a case using the zoning ordinances as your guide and try and convince the council of why it should be rezoned that pursuant to our ordinances or why it shouldn't pursuant to our ordinances, then you guys will have better testimony to make your decision.
So one of the things we said is should we ask the specific questions from the applicant and ask the specific questions of the residents of exactly what Zach said. And I'm tending to believe that maybe we need to give everybody a chance to use the zoning code as your statement of why it should or why it shouldn't be zoned that way. Again, I have not heard any evidences except for Glenn saying we're not sure what we want to do. We know what the zoning code says can be done, but we haven't really heard what it is, which to me doesn't justify changing the code at this time. So what's the pleasure of the commission? Do you want to table, postpone it? Do you want to take action right now or question all the people here in the audience? What's the wishes?
Mr. Chair, I think that we could take the time, but I don't believe that would be fair to anyone sitting out here supporting or opposing. So I'd recommend that we table and give both parties the opportunity to look at the rules, regs, and statutes, and then bring their case back to us. So if we make a decision in favor or opposed, then we've got the facts to do so.
So Zach, is tabling the correct motion, or would it be a continuance?
Postpone to the March meeting.
Postpone.
Amend my statement to postpone.
I take that as a motion.
A second.
Jacob seconds it. So as you heard the attorney and the commission state that we need additional evidence both for or against instead of just we're not sure what to do and we don't like what we think is going to happen. So we have a motion to postpone and a second, and I need a roll call vote, please.
Commissioner Baugh? Aye. Commissioner Briley?
Yes.
Commissioner Byers?
Aye.
Commissioner McElina? Aye. Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Okay. Motion carries.
Motion carries. So we're going to postpone this until the next meeting, and
It'll be re-advertised as another public hearing as we'll be introducing new evidence.
correct. So it'll be the next meeting, which is March already. Goodness, March 7th. Thank you all for coming out in the weather. Sorry we didn't get any resolution to this case, but I'm sure we will next month. Next case, site plan and concept approval for case SP 2023-4. Stephanie, you want to give an update on this? Give a staff report, please.
Yes, we received an application to develop a vacant piece of land for commercial development located at 1034 Meacham Drive. This particular property had been heard in previous years. However, that case is no longer relevant. The development did not pursue within the time frame as dictated by y'all's motion and recommendations and conditions as placed on there. So we are hearing this as a brand-new case. We do have Mr. Cervantes available as the on behalf of the property owner. He is the applicant, available for any questions.
Please come down, Mr. Cervantes, correct?
He is on Zoom.
Good afternoon.
Hi, so I need to swear you in to tell the truth, nothing but the truth. Please raise your hand and say, I do.
I do.
State your full name and your address and give us an update of what you want to do with this case, please.
My name is William, initial J. Cervantes.
Address is 11900 Vista Rose Road, Northeast Albuquerque, New Mexico. I do have a residence in Rainmaker subdivision. That address is 215 Spencer Drive. The intent here is to, it's currently has 4 properties, and Mr. Rath would like to combine all of them to one large piece of property to do a larger development. Is wanting to build a 52 plus square foot office building to move his current location into. And in order to do that, we would like to combine all the lots, current lots, into one large one.
Okay. I guess I'm a little confused. You said 4 lots?
There's 4 lots right now that are plotted.
There are currently 4 lots recognized as 7, 1, 1A, and 1B of Block 4. So that conglomerate,
zoning
that
mix
whole,
doesn't
no, the zoning map overrides the lot lines. I do apologize for that.
No problem. So it appears that there's more than one 5,200 square foot office building. What else is the plan?
The future addition of 6435 is a future building. Not sure when that would be constructed, but right now on current drawing that was submitted, we have a proposed office building of 5412 square feet with a future addition adjacent to it, totaling 6435 square feet.
So Stephanie, help my memory, please. So the case we had before us was for a medical complex or something in that area. And there was entrance onto Kirkman and one onto Meacham and I can't see the one on Meacham. Is that still correct?
Currently, the site plan that is provided was the only document that was available at the time for the creation of the case study and the development review. I have, however, stated back to the applicant, Mr. Cervantes, on all the missing documents and all the requirements as found by the development review needing corrections or modifications to be presented. Due to the amount of missing information, it was very hard for the development review to determine the grade appropriateness of the development. Mr. Cervantes has been able to piece together a few of the documents, and we are still waiting on like the landscaping plan and stuff. The most recent site plan he gave did depict a second entrance to where there'd no longer be the only entrance, which was a big concern for fire and EMS and police. I'm sorry, not police, just the fire and EMS. So for a more appropriate guidance on the new proposal, that hasn't fully been reviewed due to the time restraints and staff availability. But with the new information coming through, we would be able to perform another development review prior to the upcoming planning commission meeting for y'all to rehear or re-see any documents.
So I noted a lot of missing information. And so I guess my question is, does the staff think we as the board have enough information to consider this case?
Staff does not feel that they were provided with enough and are unable to provide you with enough to make an appropriate determination. However, staff does recognize that you as a governing body are able to follow through and maybe see something that staff was unable to. But staff does recommend this being postponed until the next meeting to give more time not only to the applicant, but to staff for future review and to provide you a clearer direction.
Mr. Cervantes, if we decide to table this until the next month, will you be able to get all the information needed as staff has requested? Will you be able to get that information in so we can see all the information as well?
Yes, that shouldn't be a problem. I've just had some questions concerning the information that has been required. This is my first time trying to pass this through, as I've taken this project over from Cape Architects and hired my own in-staff architect to continue and finish this. But what was proposed before, I felt that there was some that got approved. I felt that there was some issues there that were overseen or some. So based on a report that I got back from Ms. Warren about, say, for example, the fire, we went ahead and redesigned it so that we had a second entrance or exit on Meacham and not the only one on Kirkman. And that cleared and simplified things a little better. And that's that second layout that I had sent to her. One of the other questions that we're missing is the landscaping plan. That property has several trees that I know I got to remove several of those to be able to construct our building, but I also don't want to take any away that are natural, been there for years and years. So I was asking for a little more guidance from the department on who's going to approve the landscaping as to what exactly are they looking for? Because if I drive down Meacham, I don't see a lot of other landscaping other than the natural trees that are there. So I'm anxious to get this completed and done to get approval, but I do ask for a little bit of guidance here on some of these things that I'm not sure what exactly we need to produce.
Well, I appreciate that, and unfortunately, that is not something that the board can give you guidance and recommendations on, so that will have to be performed by the staff.
In regards to the landscaping plan, I've found out that a lot of that is based off of different calculations with our forestry department for the requirement versus parking spaces on how many shrubs, type of ground materials, and they would have to conduct a site visit to see which trees would be able to remain, which trees would have to be removed, and then whatever trees may have to be removed due to the construction sites. So I can work with him and our forestry department to get him clearer guidance on that.
May I suggest that if at all possible, I'm in Albuquerque, but if I could come down and if I could meet with the board or whomever else in the design development area and sit down and go over this, I think would be a lot easier and simpler so that I could come back to my design team and say, this is exactly what we have to do to meet the requirements and not second guess these things, because I'm just wasting a lot of time and Dr. Rath's budget. And we really would like to get this project going. And I'd be more than happy to come down and at the convenience of the design development staff and just go over every item that we're missing and get exactly what we need to do so I could propose these things to Dr. Rath and my design team and get this done.
I would agree, and again, but the board being the governing body is not the staff. So the staff would have to take care of a lot of things that they anticipate our questions will be, such as Meacham access, drainage, all the things that are going to be, I guess, under review by the staff, and we will have these kind of questions as well. So, Commission, I'm thinking that we should say yes to his invitation and table this for next meeting and have him come down in person, and in between now and then, he can work with staff on their missing information that they do not have. I need a motion to say that.
I'd like to make a motion that we table this case, let's see, SP 2023-4 until next meeting.
Do I hear a second?
Oh, second. I'm sorry.
So, Zach, again, like on the last one, we had all of our public hearings and we postponed it. This one, we have not heard any public hearing and we're just tabling it before public hearing. So is tabling the correct language on this one? Thank you. Can I get a roll call vote, please?
Commissioner Baugh? Commissioner Briley?
Yes.
Commissioner Byers?
Aye.
Commissioner McElina? Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Motion carries. Mr. Cervantes, I will be in contact with you on availability of the staff for the development review.
Thank you very much, gentlemen. I appreciate your time and effort.
Thank you for staying on hold for the last hour and a half.
You're welcome.
New business, election of chairman. So I asked to put this on the agenda because I have submitted my resignation to the mayor. I've been in public service 40 years and I'm going to take a break and I'm going to travel and I'm going to do other things and I'm not going to have the time to put into what needs to be put in for this. So I am taking my name out of consideration for the chairman, and I hope all of you have somebody else in mind, and I've enjoyed it. My last meeting, if you all don't mind, will be in April. So I've got two more meetings that I can be a commissioner, or you can leave me as chairman for 2 more meetings. So whatever you guys choose, I will take whatever you give me. So, so thank you very much for giving me the opportunity to serve the village of Ruidoso, and I hope we made some strides and upheld the vision and the mission of what they want us to do. So I'm here for 2 more meetings, and I say no more chairman for me, please.
Hey, thanks.
And you can't nominate me just for 2 more meetings. You can make it effective in the May meeting that the officers come on, because I don't mind taking the next 2 meetings.
Quitter.
As chairman, Rigsby, yes.
So I have a motion and a second, and Jacob, I need to stress.
Just call it.
I need to say, you have done your homework. You know about Robert's rules. You know all about the decorum of what a commission does, and I think you would be an excellent choice. So I need a roll call vote for Mr. Rigsby to be chairman.
Commissioner Baugh? Aye. Commissioner Briley?
Yes.
Commissioner Byers?
Aye.
Commissioner McElina?
Aye.
Commissioner Richardson?
Aye.
And Commissioner Rigsby?
I guess. I thought you guys were joking about not being there today.
No, I tell you, when you're not here, the bad things happen.
Yeah, seriously.
You got 2 months to prepare.
Yeah.
Yes, and I will say, Alan, if you'll stick on for 2 months and do chairman, because I will not be present next month. I have a work trip coming up. I'll be at the meeting, but I just won't be in person. So if you can do the next.
That's perfect. If you make it effective, the first meeting in May, I'll take the next 2. So that's no problem.
Thanks, Alan.
So, election of vice chairman, currently held by Ron McElina. Can I get a motion to nominate somebody for vice chair?
Mr. Chairman, I'd like to nominate
Second.
I third it.
Yeah.
All those in favor, I'm sorry, roll call vote, please.
Commissioner Baugh? Commissioner Briley?
Yes.
Commissioner Byers?
Aye.
Commissioner McElina?
You want to table it?
Commissioner Richardson?
Aye.
Commissioner Rigsby?
Aye.
Motion carries.
Thank you all. Anyway, so.
And thank you.
Man, thank you.
So anyway, with that news, I gave the mayor my letter of resignation today. I resigned from my position with the DOT effective the end of April, so 40 years is enough, guys.
You are quitting.
40 years is enough. I am really quitting. Community development report.
Attached in the packets, we had our department compilation. So if you have any questions on that, you can let me know. Currently, we are still moving forward with the Chapter 54 rewrite. We're working with getting the road designs incorporated into the new layout of the ordinance and how it fits in with subdivisions. We have a few more details. I was hoping to have it by your March meeting. It does not appear I'm making it that deadline, so I would anticipate April or May to bring that forward for you guys for review, also to start conducting public hearings and forwarding recommendations.
Sounds like fun.
Other than
Y'all.
that, I think that's about it for our department, but any questions you may have?
Yeah, your staffing requirements at this point, where do you sit?
As of today, we are still fully staffed with no vacancies.
Other commissioners' reports, comments? Seeing none, I'll move for adjournment.
Second.
All those in favor say aye.
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 Meeting's over. Thank you very much.
Thanks, y'all. Thanks, Alan, again, for what
You bet.
do. Appreciate it. See you guys around.
Oh, well. I don't care.
Well, we're gonna make a
Oh.
decision next meeting.
And then hit end for all. And then make sure, close down that.
You just get your shit together before you show up. Seriously, that's all there's to it. Don't scream bullshit every time.